Hello everyone. Today I would like to share an important perspective for both legal practitioners and individuals facing criminal charges, particularly in narcotics cases. One of the most effective ways for a lawyer to prepare a defense is not merely to listen to a one-sided narrative, but to study the Supreme Court's decisions to understand the reasons why narcotics charges have been dismissed in the past. Ultimately, it is not the police, the public prosecutor, or the defense lawyer who decides the case. It is the judge. Many issues that we may consider highly significant may not carry weight in the court's view, while matters we often overlook may become decisive. I will discuss one category of reasons frequently relied upon by the courts when acquitting defendants in narcotics cases: the credibility of the prosecution witnesses. First, it must be understood that criminal cases are not decided by the number of witnesses, but by the weight of their testimony. The prosecution bears the burden of proving, beyond reasonable doubt, that the defendant committed the offense. If any reasonable doubt remains, the defendant is entitled to the benefit of that doubt. The first issue the courts often examine is whether the prosecution witnesses contradict each other on material points. Minor inconsistencies, such as who walked into the house first, may be considered natural human memory lapses. However, contradictions of material facts, for example, one witness stating that the drugs were found in the defendant's pocket while another claims they were placed on a table, immediately raise doubt as to whether the witnesses actually observed the incident or whether their testimony was rehearsed and became inconsistent as a result. The second issue is when courtroom testimony does not correspond with the arrest report. The arrest report is typically prepared immediately after the incident when memories are still fresh, whereas testimony in court may take place months or even years later. Where contradictions arise on significant points, the courts tend to give greater weight to the arrest report, thereby reducing the credibility of the witness. The third issue concerns witnesses who can recall minor surrounding details, such as who drove the car, who sat where, or the layout of the house, yet cannot recall who actually found the narcotics or who retrieved the evidence. If a witness was truly present, they should remember the critical parts of the incident. Courts may therefore question whether the witness genuinely observed the event. The fourth issue arises when the prosecution alleges that an informant provided information but fails to produce the informant as a witness in court. In such situations, the defendant has no opportunity for cross-examination, and the court cannot consider all sides of the story. The courts have often treated this type of testimony as hearsay, which carries low evidentiary weight and may be insufficient to support a conviction. The fifth issue involves suspects who are separated from the case and used as prosecution witnesses. Such individuals naturally have an incentive to implicate others in order to protect themselves. While the courts may admit such testimony, its weight is significantly reduced and must be supported by other independent evidence. Our conviction cannot rest on that testimony alone. The sixth issue concerns discrepancies between statements given during the police investigation and testimony provided at trial. Facts should not change over time. If a witness provides one version during the investigation and a significantly different version in court, without a reasonable explanation, the court will doubt the witness's credibility. The seventh issue relates to uncertainty regarding the date, time, or location of the incident. If a witness cannot recall when or where the event took place, it becomes doubtful that they can reliably recount the material details of the case. The eighth issue concerns physical limitations affecting visibility. For example, when a witness claims to have clearly seen an event from a great distance at night, such assertions may contradict common sense or scientific principles. In such cases, the court may decide not to rely on the testimony. The final issue is hearsay testimony. Statements from witnesses who did not personally observe the incident but merely repeat what others told them. By legal principle, this type of testimony carries very low weight because the witness cannot directly affirm the truth of the events. Ultimately, the role of defense counsel in a criminal case is not to prove that the prosecution witnesses are lying, but to demonstrate that their testimony is not sufficiently credible to justify a conviction. If the court retains even the slightest doubt, the criminal law clearly requires that the benefit of the doubt be given to the defendant. Thank you for watching. If this content was helpful, please like, share, and subscribe to our channel so you won't miss our upcoming legal content. For any legal questions, or if you'd like us to cover a specific topic, feel free to leave a comment or contact us anytime.